Welcome, I'm Brendon Christian, Director at Christian, the law firm, and in this clip we're focusing on attempts to resolve potential disputes by the use of negotiation or conciliation or mediation. For those who are familiar with the expression, these are simply different types of alternative dispute resolution or ADR. Please note, if you are involved in a dispute, please do take specialist legal advice on the nature of your dispute and ways to resolve it, particularly if your dispute is before a court of law or indeed an arbitration of some sort. Right, so let's get to it. The first type, or rather the first way that a party can seek to amicably resolve a dispute pre-litigation is negotiation. And negotiation is effectively a dialogue between the parties. And it's a dialogue intended to reach some sort of understanding as to what the differences are between the parties, and certainly what the parties come to the table with by way of potential solutions in their own minds, to share with everyone across the table. So in a negotiation type exercise, you're looking at points of difference, you're looking at points of commonality between the parties, you're looking at potential solutions that each party is offering by way of an attempt to resolve the dispute, and you're seeking whether that works. Is that practical? And if it is, ultimately you're looking at some form of agreement to resolve the dispute. So essentially, a negotiation is aimed at some form of compromise, and it involves the parties per se, by way of a healthy dialogue between them, and that's what's envisaged in the process of negotiation. Turning then to conciliation, here we see the entry of a third party, i.e. a party not involved in the dispute at any level, and this third party is typically independent, and typically someone skilled and someone trained in the art of conciliation, and this party we call a conciliator. Now, it's important to note that the conciliation process, pretty much like the negotiation process as well, it's got no legal standing per se, and so effectively, at the end of it, the conciliator has no authority, and by that I mean he or she has no authority to, for example, call witnesses or seek evidence of some sort, or even usually no authority to make a decision, and certainly no authority to make an award. So it's important that one bears that in mind in the conciliation process. But nonetheless, in our view, it is a useful attempt. It is a useful vehicle to try and resolve a dispute pre-litigation. It's typically informal. The conciliator would meet with the parties, normally separately in our experience, and he or she will do so in an attempt to understand their respective positions, and what the differences are between the parties, and where, more to the point, where potential solution lies. And if it's a really, really good conciliator, she or he will do this by seeking to reduce any tensions, as it were, improve communication, or rather misunderstanding between the parties, try and interpret their respective positions and issues and that sort of thing. It's an incredibly useful exercise, and it's one that does require the intervention, like I said, of a trained and skilled third party, the conciliator. Upping it a notch, we then get to mediation. Mediation is another form of alternative dispute resolution, and like conciliation, mediation involves the entry of a skilled and trained and independent third party, in this case called the mediator. And typically, the mediator would try her or his very level best to assist the parties negotiate a settlement. Whereas in the context of conciliation, for example, the conciliator was at some level asking the parties to make potential concessions in the course of resolving that particular dispute. Whereas with mediation, mediators are trained to help guide the parties towards settlement. And that's quite important to understand. And so in a mediation process, for those of us who have been fortunate enough to participate in one, you will see that the mediator will, during the course of the mediation process, and they last typically half a day to a day, potentially 2 days, the mediator would meet with the parties independently, together, over the course of the mediation, perhaps once or twice like that, trying to guide the parties towards a settlement. And indeed, like conciliators, mediators are neutral third parties that facilitate rather than direct the process. So those are the three amicable, informal, easy to follow, simple processes geared towards resolving disputes amicably pre-litigation. Again, we're still talking very much here pre-litigation. Although mediation, the courts, I'm finding these days, the courts more and more are encouraging ADR, and so it's very often the case that even though the matter is before the courts, the judge might stay the proceedings before the court and order the parties to go away and attempt some form of ADR, typically mediation. So mediation certainly can happen while the potential matter is before the court as well. So those are the three instances or avenues to explore. Pre-litigation, for the purposes of the present discussion, pre-litigation in terms of resolving a dispute or potential dispute that your business finds itself in. As always, take specialist legal advice on the circumstances pertaining to your particular dispute and how to resolve your particular dispute. Please take special legal advice. And in the course of so doing, please feel free to contact us. I am Brendon Christian, Director at Christian, the law firm. Thank you very much indeed.